Well, okay. We are back on the record. Again, this is a meeting of the Legal Advisory Committee of the Citizens Redistricting Commission. Just again, to summarize, we have narrowed our applicant pool down to 5 applications, and we are, at this point, going to do a pretty in-depth review of each of the 5 applications. Ideally, we could narrow them, but if not, we will simply advance these 5 for interview. The other purpose of the discussion today is to develop a good and solid record for the both our use on Thursday as well as for the use of the full commission on Friday. Okay, and again, we've allocated the full day for this. We will take a lunch break certainly, and a couple other breaks in between. But ideally, we will wrap up by sometime this afternoon. But we will continue until we are finished with the discussion. Okay.
The only
Mr.
the only thing I would say, and because Commissioner Ward may feel like he should say it, is that really we didn't decide that the purpose of this was to narrow and then also provide stuff for the commission, but that really it's the major objective here is to go in depth and prepare a good record for the commission. And if that leads to some narrowing.
Yes, exactly.
It leads to some narrowing.
Yes, I didn't want to imply that we're necessarily going to narrow, but it may occur, it may not. But the main thing is, again, to discuss these applicants thoroughly and to have a good record for our purpose, for the committee's purpose, and for the full commission on Friday. All righty. You know, as a person whose last name started with A, I'm always loath to go in alphabetical order, but we can do that, or we can just go randomly, either way. But I always hated alphabetical order as a child, and I usually do as an adult, but we can do that if we want to. That's fine. Okay, so
So is that for an A?
Well, nobody starts with A on my list, so I think we'll go with the official name, since since a number of the applicants are individuals, but they are doing either they're set up as limited corporations or DBAs, doing business as. So it looks like F would come first anyway, but regardless. So why don't we start with Federal Compliance Consulting? Again, Mr. Adelson is the, hoping I'm pronouncing that correctly, Mr. Adelson is the head of that firm. Would anyone care to sort of start the discussion? And we can run through various criteria that we have on our grid. We can just maybe start with general impressions and strengths and weaknesses. I'm not bound to anything in particular.
I feel like we've done the general impressions already. I would like to actually start filling in this matrix.
Okay. So shall we just go ahead with some of the various criteria that are listed on our grid here? And again, I believe members of the public is that available to the public at this point? I can summarize if we, is this on the web and we do have copies? Okay, very good. And I'll as we go along, I'll simply highlight when we're, which category or criterion we are looking at. Okay, so just taking it in order. We have, actually, can I suggest we flip columns 1 and 2? 'Cause I would like to actually look at Voting Rights Act experience first, and then look at redistricting experience. And the reason I think that is distinct is because a number of firms may have been involved in either litigation or in compliance if they were affiliated with the Justice Department. But that can happen pretty much any time in terms of litigation, so it's not necessarily tied to redistricting. But certainly it is helpful to have redistricting experience. But as the public knows, this is every 10 years or so for the most part. So I'd like to at least start with relevant VRA experience in Section 2 and Section 5.
Well, I'm going to jump into that one because one of the primary reasons why this candidate was on my list was that comments, for example, during the 2000 redistricting cycle, Bruce was the DOJ's team leader for Section 5 review of the City Council plans for New York City and Phoenix and Arizona's congressional and legislative redistricting plans. I mean, that to me was, right. It could not be more on point of what we want to have done in the Voting Rights Act. So that was. So I gave him a high rating based on that.
Right. And let me and actually, just so the public knows, this is not a competitive bid, by the way. There is an exception within the law regarding state contracting that applies to attorneys and legal services. So we're not doing a competitive bid, and we're not doing sort of a formal ranking that one might see with a competitive bid process. We do have a set of criteria that we're trying to work with, and no doubt there will be ranking, or maybe trying to think along the lines of points, but we're not going into a sort of formal point system, so that the public is aware that this is not quite as regimented as a competitive bid contracting process. Just wanted to throw that in there so folks will be aware of that.
That was my basic comment on the Voting Rights Committee. It could not be more on point to me.
Okay. Other commissioners want to chime in? At least on Voting Rights Act experience.
Although I noted it earlier, under our kind of matrix, it talks about litigation experience, and again, I think it's again worthy just to note a second time that he brings as a DOJ team leader, litigation experience along with that, and I do believe he was the only candidate that brought that to the table. So certainly that's noteworthy.
Now, one thing, just a comment, not specific necessarily to this candidate, but because we do have a couple of candidates who are former DOJ attorneys, and that unless they did subsequent litigation while they're in private practice, some of their experiences are going to be different from the typical firm or attorney who's been in private practice. So that, for example, a Section 5 review by the Department of Justice is a certain kind of experience where you're looking at the application, you're looking at the law, the regulations, you're trying to look at the facts, you may be working with some experts to determine whether a particular change in the law should be pre-cleared, whether there's retrogression, which is one of the legal standards for Section 5. That's a little different. Well, it can be different from what one might see if one were going to be litigating a case or bring some sort of court action. Even though, again, the Justice Department does litigate cases, certainly Section 5 and Section 2 on occasion. So compliance work, no less important, certainly, but is going to be sort of different from what we might see with a firm who's litigating. So, but I think this candidate has a lot of very, very relevant experience, certainly, in terms of having been a DOJ attorney.
I just wanted to point out that further on in his application, in addition to doing the DOJ legal work, which includes the type of litigation and certification that you described, if you look at page 11, when he was in private practice from 88 to 93, he has done federal trial and appellate court practice and jury and bench trials. And some of the cases are quite complex. They're not voting rights, but they're, clergy malpractice in the case of first impression, financial fraud, legal malpractice and defect litigation. Those to me, that's complex litigation that has its own, that even though it's not voting rights, is the kind of complexity in terms of analysis you have to do, financial and discovery and, appearing in court. So I think that he has a lot of litigation experience, more than other candidates, even though it's not in the voting rights context. It's been a while, that's true. So it's not recent, and maybe some other candidates have more recent, but I wanted to point out that his litigation experience does go beyond DOJ litigation experience. The working with public and private boards and commissions, I wanted to talk about this application in terms of that. I think in reading this, when you see his training and technical assistance, it's not necessarily boards and commissions, but you see that he's, dealt with state election directors, district and county attorneys, associations, airport authorities, tribes, various tribes, Department of Transportation in Maryland, Transit Authority. So you get the sense that this is a person that does understand public entities very well, both at a very local level and at a state level, and I'm not sure if at how much at a federal level, except DOJ, which is federal, of course. So my thought, especially after looking at his PowerPoint that he did for the Navajo redistricting, that he...
I'm sorry, just, that's something that was available online?
I think he has a link to it.
Was it in the packet?
Because I think that's how I got it. But I'm not sure.
Okay.
Was that... Do you remember? It's a link or something? I got it. I don't know
So
if
it's
I
not,
linked
it may not be available on the commission's website,
Site.
but there may be an active link, or at least an
Yeah,
indication
so-
of what that is on
So
on
when
his
I looked,
application.
when I looked at that, I thought this is a person that, like I indicated earlier, that in terms of, so that I talked about the working with public boards, in terms of meetings with commission consultants and communities, I was very impressed with the roadmap he laid out for one particular redistricting that included all the meetings, what they were going to look like. It's exactly the kind of work that we've been wanting to have somebody tell us what the attorney does in this in this process that we're about to engage in. Cost. I think the cost. My sense from looking at the other applications, so it was 2,000 not to exceed, which I liked.
Yes.
I like the not to exceed language, and he is hopeful that it would be less, and that seemed comparable to the other applications. That didn't seem out of the range of other folks, and his travel was actually, I thought, very reasonable and average with others and lower than others that we received. So I thought it was, in terms of cost for us, it was competitive in the sense of that it's not out of the range of the other applications.
Can I make a comment on cost real quick?
Yeah.
Just
Sure.
before we leave.
Commissioner Ward?
I just want to note that his fees were in line, it did seem, but he did stipulate on his public meetings to a 3-hour time frame for that.
Oh.
And I just want to make note of that as we
Right.
as
Yeah.
we line item their expenses.
Yeah,
Right, so that was an assumption that he stated.
that may not
No
be.
meeting would last more than 3 hours, and
Yeah.
that's the dollar figure he quoted. Obviously, it would be higher.
But he was also including prep time in that.
Yeah.
Right.
The main concern, and this is what I would really want to focus on in the interview with this candidate, is his capacity as a sole practitioner, to do this. And it appears that he has other clients right now. He lists in page 5 that he's going to be representing Gila County, Navajo, Pinal, Greenlee, Graham, Mojave, mostly tribal districts, and mainly in Arizona. So I don't know how much time that takes, but that's a question I had in terms of does he have a staff? How is he going to
Right.
staff a California project and his other current clients for the redistricting? So that's really, everything else for me was outstanding, but I am concerned about capacity.
Other commissioners?
I just want to echo, I had restricted my comments to Voting Rights Act, but capacity was an issue for me. But other than that, I thought it was, across the board, an excellent application.
Commissioner Dye?
Yeah, I liked also that he has this extensive training experience and got good ratings on that. I mean, again, speaking as a non-lawyer, I want someone who can explain things to me well. So to me, that was a plus.
Commissioner Ward?
thank Commissioner Blanco for that thorough input. I think it's great things to think about, and I agree with the capacity concern. I in the interview would want to know if that's why he wanted to limit the 3-hour public meetings, being that again, when you consider travel and everything else, all his other clients, if how available he is going to be to the commission's needs.
And, and I agree with all the concerns that have been stated, as well as both the very very strong degree of experience that the candidate has. One thing we might want to think about as we're moving forward, and this is like for the full commission as well, is we have a general sense of what we would like and what we think we need from the voting rights attorney. But I think as we're moving forward, and certainly by Friday, I think this should be part of the discussions. We're getting pretty clear on what the time commitments will be, and I think particularly when we're dealing with anyone who's out of state, that there's a very clear sense of what could be done out of state and what would be essential for the anyone that we retain to be obligated to do. So, for example, there may be certain meetings that they have to be there, whether it's input hearings or business meetings or various discussions where we're actually reviewing whether it's Section 5 or Section 2, potential Section 2 types of districts that our attorney is with us, not by phone or being contacted by email. So I think that's something we should be asking anybody who's out of Sacramento to some extent, to know what your ability and to be with us physically in terms of meetings and other types of needs that we might have. But I agree. This is a very very strong candidate. Has a lot of very close experience. Doesn't have as much. Again, to the extent that someone has sort of entered the private sector, may not have as much sort of recent Voting Rights Act litigation experience, but I wouldn't consider that a liability necessarily. And has a very good record, I think, in terms of. I think this can come out in the interview, but that appears to have a very good record working with public bodies and as a trainer, which I think will be very useful in terms of advising the commission as a whole. So I think that'd be a great asset to us. And again, I agree with the underlying concerns regarding capacity. And again, anybody who's sort of a solo, I would be very, very careful about asking what their other time commitments are and what they'll be able to bring to us as the state of California's body. Okay. Any additional comments on this candidate?
Just to note that there are no conflicts of interest.
Right. Okay. Are there any members of the public that would care to comment on the application of federal compliance consulting? And again, this is LLC, Limited Liability Corporation, so the attorney and CEO is Bruce Adelson. Is there any public comment at this point on this application? And we'll probably have a summary opportunity at the end, but if anyone wants to come up, we're happy to take your comment at this point, and just limited to this particular application at this point. So,
I wanted to follow up on a comment I made earlier about really looking at the degree to which applicants promote public trust in the commission's process, and I think this applicant, Federal Compliance Consulting, scores very well in that area. As a former DOJ attorney, he's the sort of applicant, or his firm is a sort of applicant that kind of lets people know he's got experience in carefully measuring questions of VRA compliance and has judiciously used the government's resources in pursuing VRA enforcement claims when necessary, and has experience in vindicating those sorts of claims. And so I think for those reasons, I would say his firm does pretty well in that area, very well in that area.
okay. Thank you, Mr. Lee. Are there any other public comments at this time? Okay, seeing none.
Can I just point out one other
Just
thing?
go ahead.
Just for a question on Thursday, and it may be just a one question, it deals with capacity. In his statement of qualifications, he says he will be the principal attorney spending time, but that implies that there could be others. So
Sure.
the question is, are there others, or is that just the way the language came out?
Okay. Yeah, and I think that's a very relevant question to ask any of the again, smaller candidates. Do you have a current capacity for additional? Do you have other attorneys, or will you be able to take on
Right.
additional capacity to provide the services? Okay. Anything else on this candidate? Okay, so let's move on to GRD Consulting. Excuse me, Consulting, and this is.
Actually, do we want to do Gibson Dunn?
I'm sorry, did I? Oh, I'm sorry, you're right. I had them at the bottom of my list, and they are alphabetically earlier. Are they? Okay. So Gibson, Dunn, and Crutcher. Let's start up at this point. I'm locating them, sorry.
Commissioner Anchetta, before we start this conversation, in keeping with our disclosure requirements, I know Mr. Brown well. When I was the executive director of the Lawyers Committee for Civil Rights, he served on the board of directors, and so he was my boss. And he was co-counsel on cases that I had the ultimate authority to approve, that I approved and had the authority to settle as executive director at the Lawyers Committee, and he mentioned some of those cases in his bio.
Okay, so the Lawyers Committee for Civil Rights in San Francisco was co-counsel on Sanchez versus City of Modesto. Is that correct?
He worked with the Lawyers Committee on the Sanchez v. City of Modesto when I was there.
Okay.
I think the Madera School District case was after I left. I'm not sure. And there was another, I thought there was another case, but maybe he didn't work on it. I thought he had done a case with us in Merced about...
And that may simply not have been highlighted in his application.
I thought he had done a Merced case at the Lawyers Committee that was also a voting rights case. But I do know him, and in fact, when we were asked to go out and drum up candidates, I called Mr. Brown and told him how exciting a position this was, and that I thought, given his experience, he should apply. So I just want to disclose that.
Okay. And just for clarity's sake, you are, of course, no longer affiliated with the Lawyers Committee for Civil Rights. And do you know if Mr. Brown is actually still on the board?
He is the chair of the board now.
He's still chair.
And I'm no longer affiliated with them. I'm not on their membership, and I'm not affiliated. But you know, I have worked with him, and I do know him.
Okay.
I should say that it was a work relationship, and I don't think it impairs my ability to be fair and unbiased. If anything, I think I might be able to help the commission with some insights about him and his qualities. I don't know the other member of the team he's proposing to work with.
Do any of the commissioners have any questions about this, about just the disclosure by Commissioner Blanco? Okay. So we're open for comments again.
So let me make a few kind of preliminary comments. So this was the application that noted that there were 52 congressional districts. So to me, that's an attention to detail thing that I would expect from a large firm, that they would have plenty of people to double check those kinds of things. Having said that, I liked the fact that you might say that this firm has kind of taken a bipartisan approach in their selection of attorneys. I think that Mr. Brown clearly has extensive experience representing minority groups and defending the California Voting Rights Act. It's done those racially polarized voting analyses. And then Mr. Colby was very involved with drafting Prop 11 and Prop 20, plus the predecessor, Proposition 77, that failed, but has clearly strong Republican ties. I like the fact that they recognize that this was an opportunity for public service on the fees part. So those are a couple of my comments.
Excuse me, other commissioners?
Yeah, I just have one comment on the fee structure, and I'll have others as well, but it was a minus for me that they don't give you a number. That you have to pick us first, and then we'll figure how much we're going to charge you. I mean, that was troublesome to me.
Mr. Ancher, if I might, I noticed that obviously as well in the review, and did call Mr. Brown to see if they could elucidate us a little bit further on that, and obviously can't speak for the firm, but in the discussion, he indicated they had done some more work on the issue, and while this is preliminary in all respects, their firm structure is similar from a fee perspective to the other large firms represented, in that a partner at his level, Mr. Koke's level, would typically bill at about $800 an hour or higher, and the number suggested was about $500 for this work.
Was it your sense that there would be a proportionate reduction in, say, less senior partners or associates?
We actually did not address that issue.
Okay. Well, that's certainly helpful information. But I'd share that concern too, that we don't have at least some ballpark figures on the full range of services. And again, I think a number of the other firms have indicated at least senior partner level, partner and associate level fees, and whether they can reduce or not, which this firm has not given us too much detail on.
May I just add, understanding that 500 per hour addition, and I kind of had the same question as regarding what other fees and travel and hearings and all the other information. One caveat they had on there was that any fee proposal would have to be approved by their management committee. And I just, again, being a non-lawyer, was concerned as to what that means. Maybe there's a standard explanation for that, but I'm not aware of what that is.
Yeah. Well, it's a big, yeah, I mean, and Mr. Miller can chime in, and others can chime in as well, but, it's a big firm, and they're in business. And whenever there is certainly either a reduction in fee or any possibly a pro bono activity, you want to know how much money the firm's going to make. And I think, like any business, they can adjust their fees as appropriate for a particular client, but they have standard fees that they bill at, and if they're going to reduce it, that has an impact on the whole firm. So, and typically the way larger firms will work, there will be a managing partner or a managing committee that stays on top of a lot of these questions across because these are very, very big firms, hundreds of lawyers. So that's sort of the oversight committee in terms of that question. And again, presumably this is a pretty significant job for the firm, and they want to know, well, there has to be somebody in the management that's saying, okay, that's fine. We trust you, or that's not going to work for us. You need to kind of negotiate back with the client to do something different. But it sort of represents the internal decision-making structure of a large firm.
Should there be an interview? Is that information that we would expect them to have a committed idea to as a fee structure?
I would think they need to speak to it. I mean, because, I mean, and this is something maybe we can come up with a number, or we can look at the other applications and see. I mean, $500 an hour in and of itself doesn't mean a thing unless you can know the hour multiple.
Right.
And so, I mean, what are the other, what are other firms estimating, or what do we estimate the number of amount of time it's going to take? And then we can multiply by 500 ourselves and come up with our own gross number.
Right, and that's partly our responsibility. I mean, a lot of it is our responsibility too, because we need to decide. Well, we have X number of dollars. Now we've budgeted that. We can go up to that if we need to exceed it, because we really need to get certain products or advice done, we can face that as it comes by. But I think and I'm glad Commissioner Dye is here as well, because I don't always remember all the numbers we had in the budget. But it's really important that we are sticking to that budget. And a number of these firms, well, all of them, they come at a cost.
And it's all fine and good to say that the management committee has to approve it, but I do not want to get to the place, we pick you, everybody else go home, and all of a sudden the management committee says no. And now we are in a hard place.
Right.
And I think that's a place I don't know that we can go.
Yeah, that's a very good point. Yes. But again, and I think Commissioner Ward, this is very helpful. When this is exactly why we like you to speak up on these issues, because again, you represent a sector of a large, or actually the majority of the commission, in being a non-attorney. So it's very helpful. Oh no, but members of the full commission.
Right.
On the committee, also we have a majority of lawyers, but on the full commission, we have most of them. Thank goodness, are not all lawyers. Okay, other comments on Gibson Dunn?
Well, I'm going to be methodical on all of these.
Yeah.
So, in terms of starting with the voting rights experience, section 2 and 5, between the two attorneys that are presenting themselves here as members of the team, Mr. Brown and Mr. Kolke, they do have that experience. I want to say a little bit about Mr. Brown's experience. He talks about it, so it's not just my personal knowledge, it's in the application. California has a Voting Rights Act that was passed, I don't know, 5, 6, I can't remember how many years ago, in the last decade, that in many, many regards tracks the Federal Voting Rights Act. It has some variations, which I don't want to bore you with the details.
Just for clarification, that it should not apply to our work, because it really applies only to local government. But just in case you're wondering, where did that law come from? But it isn't directly applicable to the commission.
Right. So, because it's one of those situations in the law where two statutes are parallel to each other and one's modeled after another. Mr. Brown's litigation has been in that arena in the California, with the California Voting Rights Act. But the work that you do in terms of analyzing whether a electoral district violates Section 2 is the same as under the Section 2 of the Voting Rights Act. You have to look at the impact on minority representation. As he describes, he's had to do numerous racial polarization analysis for the cases, because he's been on the plaintiff's side where you're alleging that a particular configuration violates Section 2, so he has to do a racial polarization analysis. The difference are in the remedies between the two statutes. So I think his experience qualifies there. I want to interject, because of my knowledge, that I think Mr. Brown is extremely sharp lawyer. I mean, I've worked with him. He's his demeanor is very calm. He's very deliberate, very knowledgeable, very soothing. He is. I mean, he's the kind of person that would really work well in a team. And then Mr. Kolke's experience is more directly federal experience. So I think they comply with that part, and also with the redistricting experience, particularly Mr. Kolke, not so much Mr. Brown. Litigation experience, the same, but I think both of them have that. Both the members of the team have extensive litigation experience, and recent, which is important. Working with public and private boards and commissions, I didn't see as much in here as maybe others did, as I've seen with some of the other people that we have in the pool. So I don't know with in either column, working with public or private boards, or training and, you know, that kind of stuff that we talked about with the other candidate, ability to train and interact with the public in hearings. I don't know that they've done a lot of that public hearing or commission work. So I don't know. I think, you know, their vast experience kind of outweighs that, and their litigation experience definitely outweighs that. The one, so I don't think they really have that. In terms of conflicts, I think that we got public comment verbally, and I was just going online to see if we'd received any written public comment, and it was the same one that was read earlier about Mr. Kolke as having represented one, he's been within the past 10 years, he's been associate member of the Central Committee of the California Republican Party. And for commissioners, that would have been an automatic disqualifier. It actually states Central Committees of the state. I think something in the perception column that could be quite controversial was that the firm itself, Ted Olson is an attorney with the firm, and was the attorney in the Gore v. Bush, was the lead attorney in the Gore v. Bush case. And that's not Mr. Kolke, but it is the firm, and he's a partner in the firm. And that might engender some, you know, if we go on this trust model versus direct conflict, which are sort of two different ideas that I think have been helpfully interjected by the public. I think there might be some issues around both Mr. just about Mr. And I'm not rambling, I'm trying to find the section. Mr. Kolke he represented the Arizona House of Representatives, and that was the Republican House. And in fact, the court eventually rejected the Republican plans that were drawn there for Congress. And he has represented Republican governors when redistricting plans have gone from the legislature up to the governor. He's been represented not Democratic governors, but rather Republican governors. On the flip side, he was an appellate judge, which I think speaks highly of his ability to be impartial. And that's a strict review that the judicial, that, you know, when judges are nominated, that's always something they look for in their qualifications. And obviously he's passed and did serve as an appellate judge. So I think that kind of mitigates some of the, potentially some of the bias concerns.
Commissioner Ward?
Yeah, I just wanted to add that I thought equally that this was my second choice when I ranked them. I felt that considering those conflicts of interest, that this firm demonstrated that they had played kind of all sides of the field, you know, in representation, and it was noteworthy that I believe it was Kolke, if I recall right, was a principal drafter of Prop 20 and a draft assistant of Prop 11. So again, definitely something to consider, and again, considering public comment being that they've worked with leading voting rights advocates, and I think the racial polarization experience is again all experience that's relevant to what we're looking for.
Other comment? I'll chime in a minute, but other comments? Okay. And I'm not going to hold it against Mr. Kolke that he advanced the deadline to August 15th. That's just the way it is.
Oh, yeah.
Or that they forgot to update the 3-day notice in the last month, but that's okay. I agree with all the comments so far. Again, I think it's not quite as deep in terms of voting rights experience, and certainly I think it's comparable. Look at the California VRA as having very similar legal requirements, and in terms of litigation and working with expert witnesses, I think that's directly relevant. So, and again, it's not quite as deep as we might see in other applicants, but I think it's certainly strong experience. And again, I think it's very interesting. You do have at least the primary attorneys that are listed are sort of not necessarily mirror images, but sort of complement each other in terms of both background and work on plaintiff versus defendant side. Mr. Kolke, of course, has a number of different sort of experiences related to, and this, it is an issue, I think, in terms of conflict, in terms of working with Republicans, but it's certainly not an automatic disqualifier. I want to explore some of that more thoroughly if we're to move the firm forward. But I think it presents an interesting balance, I think, in terms of having both the lead attorneys having somewhat different backgrounds. I share some of the concerns about whether the ties to the Republican Party are so strong that they might be disqualifying. But I'm not at this point willing to say don't come in for an interview. I tend to rank this firm somewhere in the middle, however, not necessarily close to the top, because again, the depth of experience is not quite the same as others. But I think that, again, there come a number of advantages with working with a large firm, not the least of which is basically around-the-clock service when you need them. That's one of the advantages of a large firm. And when there are very tight deadlines, they can get the work done. I have no question about, or no lack of confidence in that ability. But again, I think I share both the merits of the application as well as some of the concerns about potential conflicts. Other thoughts? And again, I'm not quite going through every point, but I think Commissioner Blanco covered them fairly well in terms of each of our criteria. Okay. So no additional commissioner comments. Okay. Again, another opportunity for the public to comment on this application. The application is for Gibson, Dunn, and Crutcher. Please come up.
Commissioners, I wanted to make a couple comments with respect to this applicant. I wanted to start off by going to Mr. Kolke, and as Commissioner Blanco pointed out, if the committee or the commission were to apply the conflicts provisions in Prop 11 to Mr. Kolke, he technically would be conflicted out because of his election to state office within the past 10 years and also his membership in a party central committee within the past 10 years. And so I just, I think that's worth noting in terms of the question of public trust in the commission's process. The conflicts policy that the commission has adopted gives the commission the discretion to apply these conflicts, and if the commission were not to apply these conflicts, then that would be a conscious choice not to. I think that the parallel situation to Nielsen Merksmer is a little bit different in the sense that Ms. Leone is the lead attorney for, or would be the lead attorney for Nielsen Merksmer, and she would be conflicted out in the same manner as Mr. Kolke would be if the commission applied the conflicts to all applicants. But with Nielsen Merksmer, if Ms. Leone were firewalled out of involvement, that seems to raise into question the service that the firm would provide, given that she was contemplated to be the lead attorney, and as their application states, involved in 100% of the work that the firm would do for the commission. Whereas in this instance, it's a little bit different if Mr. Kolke were to be firewalled out, but Gibson Dunn were to continue doing work for the commission. The Gibson Dunn application doesn't quite spell out the percentage breakdown or allocation of work among the attorneys, but one can just kind of look at the numbers, and if Mr. Kolke were firewalled out, there would still be 3 members of the Gibson Dunn team who would be working for the commission. I wanted to address the question of perceived partisan balance, and I actually don't think that's an issue here. If Mr. Kolke were conflicted or were firewalled out, I don't think there's a perception that the remainder of the Gibson Dunn team would be partisan imbalanced. The work that Mr. Brown and the two associates have done in vindicating California Voting Rights Act claims, I don't see as partisan work at all. I want to be very careful not to conflate partisanship with pro-VRA work or pro-California Voting Rights Act work or work to advance electoral opportunities for underrepresented communities. And so if Mr. Kolke were conflicted out, I don't think that creates any sort of partisan imbalance. And so I guess the last comment I want to make is to raise the suggestion that perhaps the Commission might want to go back to Gibson Dunn and ask if they would be willing to render service without Mr. Kolke as part of the team, given that the remainder of the team seems very capable, has done a lot of work around racially polarized voting, as was previously mentioned by the commissioners here today, and has done a lot of work to try to promote equal opportunities for underrepresented communities. So as I was sitting in the audience, that struck me as an interesting possibility that the Commission may want to consider.
Can I ask you a question, a follow-up question? So you're equating Ms. Leone's current being a registered lobbyist with the fact that Mr. Kolke was in the subcommittee within the last 10 years.
That's right. Both would constitute conflicts under Prop 11, the same conflicts that applied to the Commission selection process. Those conflicts included being a registered lobbyist within the past 10 years,
right, or
being elected to state office, or being a member of a party central committee. And so, yeah, I think you're asking.
My point is, and I haven't decided where I'm coming down this, is that one is a current active lobbyist role. The other is something, I don't know how long ago it was, but it was a while ago. So granted, and since we do have the discretion, apparently, of the ability to decide how these things play out, I just wanted to get your reactions to whether they were the equivalent. Something happened 10 years ago, the equivalent to something's happening today, and that's what I'm pondering.
Mm-hmm. That's a good question. I'm not sure I'm prepared to answer.
Right, that's just a response I have to the committee members.
Yeah.
Whether we're talking apples and apples or something that's going on.
Right.
Thank you.
Thank you, Mr. Wood. But I think Commissioner Ford's raised a very good point, which is in looking at the conflict of interest policy, and at our last full commission meeting, we had some discussion about this, and the formal policy that we're adopting is based, at least for staff, is basically not as rigid as the Voters First Act's requirements for commission membership. But it's a really good question, which is if we're going to stray from that a little bit, how far could we stray or want to stray?
Right.
And I think I certainly want to reserve that for some discussion.
Right, exactly.
Not right now, but I think it's a very, very good point to raise. Okay. Are there any other comments on the Gibson-Dunn application? Okay. Shall we move on to, and I have GRD Consulting. Okay, so this is Professor Gilda Daniels. I'll disclose something that's not, I don't think it's that big. I've met and I've been on a panel with Professor Daniels, I think a long time ago, like a year ago. I was on a panel at Indiana University in Indianapolis. We were on a panel on election administration. I presented a paper, and I think she was moderating. I think we may have met on some other occasions, but that's about it. FYI, not a major connection, obviously.
A couple of things that I have, I'll just jump in there. I can't tell from the application the extent to which she has litigation experience. She says she has some, but I can't tell how much. A second concern I have is her ability to respond. With another job and being on the East Coast, the ability to actually service our meetings, I have a concern about that. Also, I don't know that that I can tell from her application that maybe I missed it, but that she has had much experience of working with public and private boards. So just some of the comments that I wanted to make.
Other comments at this point? Well, and this goes to VRA experience. I agree that it's not entirely clear from her application, although we might be able to infer a few things just given her position. But I'm not sure. Given her position, which was deputy chief, which is a senior position within the voting section, I don't doubt she was supervising a lot of litigation.
Was or wasn't?
Would have been supervising.
Oh, she would have been.
But having said that, there's really close supervision, and there's really sort of being on top of the case and being the chief litigator, versus I'm doing a lot of other stuff, including managing this department and that department, and I'm delegating a lot of responsibility to my line attorneys to actually litigate the cases. So I'm not clear, based on the application, whether it's the former or the latter or some combination of things. I'm assuming that certainly in terms of knowledge and expertise, she would be able to. She has quite a lot of experience in terms of that. But in terms of direct litigation experience, it's not entirely clear from the application what she did as the deputy chief, and to what extent she had control over. I suspect she had a fair amount of control over the dockets, in the sense that she had a fair amount to say, subject to the chief's approval, of whether certain cases would go forward or not. But again, whether she's, sort of deep in doing depositions and working on pleadings and various elements of litigation, I'm not entirely clear.
Can I say something about that? So I was very, very impressed with this application for a variety of reasons. But just on the question of which I'll do my little methodical thing later. But somebody's got to do it.
Well, we're waiting for you to do it. I'm just deferring you. Go. I was not responsive to Stan, but but go ahead.
But in looking at the resume, which is attachment A on page 8, so as deputy chief, she states that she directed all phases of discovery and conducted settlement negotiations, and that she supervised the attorneys. If you go down one to her tenure at the Lawyers Committee for Civil Rights under the Law Voting Rights Project, it states that she litigated violations of the Voting Rights Act, particularly Section 2 cases, and the National Voter Registration Act at both the federal, trial, and appellate levels. So, and then highlights that by saying that she conducted all phases of discovery and negotiated agreements. So my sense is if she didn't do it as deputy chief, she was definitely doing it in her time at the Lawyers Committee, and in fact argued the cases.
Prior.
And then
because she was
right,
on
and
the
then
line.
I get back, and then you keep going to her first tour of duty at DOJ, and she does say that she litigated the cases, did the discovery, and that she argued several cases in the federal district court. So I think this person has tremendous voting rights litigation, discovery, et cetera. So I'm not concerned at all about her litigation. In fact, I think she may be one of the ones with the most litigation, if you include discovery, which, as having been worked in a nonprofit as opposed to a big firm, when you work at a nonprofit like she has, you do your own discovery, you do your own litigation, you do your own interrogatories, you prepare your argument, which is not necessarily always the case with big firms and partners. There's a different level of hands-on litigation experience. And so I would, without knowing the details, it's very possible that because of where she's practiced, that she has the most litigation, direct hands-on litigation experience of other than, say, FCC counsel, that she, as compared to the big firms, she might have more. I'm not sure about that, but it's there for.
No, I ranked her close to the top in terms of my, at least in that, certainly that criteria.
Yeah.
I guess the one question I had was just how much, and I'm assuming that there was some work done around the 2000 redistricting cycle. It's not highlighted, as far as I could tell in particular. But I'm assuming, obviously, with particularly just doing Section 5 reviews, that she was involved in that.
that's
given
what
the
I'm
time,
assuming,
yeah.
that she's at DOJ at that time, but if you look at the timeline, and that she was reviewing a lot of the redistricting plans that came before, which is
That
incredibly
was when she was
helpful.
deputy chief.
Yeah, which is very helpful. That means that all the redistricting people, we should ask her that.
Yeah.
But that all the redistricting plans that had a Section 5, that were in a Section 5 state, it looks like her division would have been reviewing those. So that would be, something to ask, but I'm sort of assuming that she did all
Yeah.
the redistricting reviews. So in terms of redistricting experience, like you say, it may not be the same as with the folks that actually were hired as attorneys by the Republican caucus or by the Democratic Assembly members in this or that state to do the work as attorneys, but she did it possibly in the review process. There's a different participation in the redistricting process, which I like, the fact that the participation is more of a reviewing the redistricting plans rather than, although both give you a tremendous insight to how it's done. I don't know, as I think you indicated, or maybe somebody else did, how much she's done in terms of public boards and commissions. I do see a lot of panels, and by the way, there is a litigation on page 10. She has all her partial list of cases that she's been involved in. It's quite lengthy. She has participated on a lot of panels, and I sort of, that's not quite training, but it's a little bit like that. And the cost, I thought, was in line with the other applications. It's 200, which is pretty similar, 200,000, and she says should not exceed, but that she thinks it could be less. So, again, I think that's up to us to kind of begin to really narrow that down somewhat for people. And her travel was lower. Her estimate for the travel expenses was lower. Finally, I would say that the one thing, of course, that does concern me, and I like the fact that she cited very recent cases around the Voting Rights Act, like the most recent Section 5 case, et cetera. My concern, of course, is her that she's on the East Coast. I don't know if she could take a leave from teaching. I would explore that with her, whether she could and whether she could move out here for the duration of the work if she took a leave. So I'd want to really, really explore that with her. Finally, I think it would be really great to have a woman. She's the only. Well, that's not true. Leonie also. So it would be, but it would be great to have a woman of color on the team, both a staff team and also on this, sort of the redistricting team. But we have good diversity in our candidates as it is. But that was a nice thing to see. And we had talked a lot about professors, and here we are, DOJ and professors. So that was a plus for me.
Other comments?
And no conflicts.
That's right. Mr. Ward?
Again, great candidate. I think across the board she scored high with all of us, I believe. So I think that speaks to the strength of her application. And Mike, I do share the concern of capacity. Lawyer once said that big firms are big for a reason. You know what I mean? 'Cause they can handle a lot of clients, and I think that's a valid concern that I definitely would want to explore in an interview.
Yeah, and I'd concur on all the remarks that have been stated so far. Again, just outstanding level of experience with the VRA, but can you do the job, basically? I'm assuming she has her summer off, but I'm also assuming that she has some teaching to do over the next month or so. But I think we should just ask her that, and what her capacity is given and I'm not clear exactly what other work she's doing, so that would be important to sort of flesh out whether there's any additional capacity problems that may arise because of other clients she's dealing with.
So I just wanted to also comment that she was deputy chief under both Clinton and Bush administrations, which I thought was great. She also mentioned Section 203, minority language, and also another section that I wasn't even familiar with, 208, which you guys may know. So,
Yeah, I'll tell you what that is in a second.
yeah, I mean, I just got the sense she had incredibly deep experience in terms of exactly, what we need in terms of VRA experience. In terms of working with boards, and I thought maybe commissioners, you guys could answer this. I mean, she was working with a nonprofit, so I think that by definition she would have had experience working with boards. So that would be my comment on that. And then as a teacher, you would expect she has some experience explaining things. So.
I hope so.
Let's see her evaluations.
Right.
Yeah.
Yeah, and Section 208 is a section of the Voting Rights Act that has to do with folks who need help voting and the right they have to bring in a personal assister in. And it's typically involving someone who might have a disability, or it's also used very often for individuals who are limited or non-English speaking, and they can bring someone to help them read the ballot. Again, it's not directly applicable to the Commission's work, but it's an important part of the law. Okay. Any other Commissioner comments before we take public comment? Okay. I'm not sure if Mr. Lee's coming up after everybody. Do we have any public comment at this time? There will be opportunities, I think, at the end as well, as if you want to formulate some additional comments. Open here, come on. There's not a long line, so happy to hear you.
Commissioners, I wanted to make two comments. The first is, I think that this applicant, similar to Federal Compliance Consulting, LLC, does very well in terms of engendering trust among California's population, given her work at the DOJ voting section, as well as her work at the Lawyers Committee for Civil Rights, doing voting rights work to provide equal opportunities for underrepresented communities. The second comment was that I wasn't sure if I got this all right, but it seemed like there was some question about the depth of her experience in during the actual redistricting process, and I think that I would say, based on our cover letter, which I think that commissioners may not have looked at quite as closely as her resume and statement of qualifications, but her cover letter does talk about her having been involved with Section 5 submissions and Section 2 investigations during the during the 2000 round of redistricting. And certainly it would be good to talk to her about that experience, but I think that, at least on its face, her application demonstrates that she does have that kind of experience, in case there was any question about that.
Okay. Great. Thank you. Any additional public comments at this time? Okay. Let me just ask the Commissioner what we want to do. We've gotten 3 out of the 5 done. It's about 10 to 12. Is there a preference either for a lunch break or to continue on at this point? Any preferences?
I'm a fan of pushing forward.
I'm sorry.
No, there we go. I'm a fan of pushing forward with the clause of a bio break.
Keep going.
Yeah.
We might be able to go through all 5, actually, depending on how we're doing. Okay. Munger Tolls and I'm sorry, Commissioner Board.
I had a clause. The bio break.
Oh, I'm sorry. I'm sorry. You do want to take a bio break. Okay. All right. Let's take a 10-minute break. So this is just a break until noon, and we'll resume at noon. Okay. Thank you. The bio break kind of slipped by.